Good morning, afternoon, or evening. This is a recorded presentation that I've given in April and May of 2020. It's entitled Insurance Agents and Brokers, Duty of Care, and Issues Presented in the COVID-19 Claim Environment. I want to thank you for taking the time out of your day to listen to this recording, and I hope you're doing as well as can be expected in these difficult, uncertain, but hopefully improving times. I'm here sheltered at home in my home office in California with my dog. You may hear from time to time. At the end of this presentation, you may decide she knows more than I do, and you're probably right. Making sure your family and clients are okay is paramount, and I'm going to focus on the professional side of things today, talking about risk management for insurance agents and brokers in this COVID-19 environment. As some of you may know, in my prior life for about 25 years, I was a practicing attorney and represented agents, brokers, and their E&O insurers in professional liability, E&O, and coverage matters. I now work on the E&O production and claims side with CalSurance and our TPA Lancer Claims, designing E&O programs and claim handling programs as well. A couple of procedural items to start with. I've timed this presentation for about 45 to 50 minutes, leaving 10 to 15 minutes for questions and answers at the end. I'm good, but not that good, and cannot add questions for my own recording. The next best thing, and perhaps even better, is that my cell phone number and my email will be on the last slide of this presentation. So feel free to email me or call and leave a voicemail on my cell phone with any questions that you may have. Odds are you're going to face a claim at some point in your career. Over 50% of agents do. My goal here today is to help you prevent or minimize the impact of such a claim, especially those that arise out of a crisis situation. Win or lose, an E&O claim will cost you time, money, aggravation, agency resources, and potentially your reputation. And this becomes magnified in a crisis situation. So as part of this presentation, I'm going to start with trying to present an understanding of the duty that you owe to your client within the landscape of our ever-changing insurance industry, especially in times of a CAT situation, whether it be hurricanes, wildfires, and now COVID-19. It seems like every day I read something new about COVID-19 related insurance coverage, agent broker E&O claims, lawsuits, legislation, and the like. So far, most of the buzz has been about the availability of business interruption coverage, so that will be my focus today, especially when talking about E&O risk management, as well as other claim-related issues, although I will touch upon other items and lines of business as well. To get a better feel for the possible claim environment we are in or about to enter into, I thought I'd begin with an advertisement I read last week or two ago by a Florida plaintiff's attorney that included the following statements. An insurance agent's negligence claim can arise when your insurance agent makes mistakes that lead you to believe that you have coverage that you don't have. For example, suppose you paid for property coverage and later found out you lack or did not have enough business interruption coverage because of your insurance agent. You are eligible to file an insurance agent negligence claim to recover damages caused by not having any business interruption coverage or not enough business interruption coverage now faced with the coronavirus pandemic. I am a Miami property insurance attorney who could help you fight to recover the amount you would have received if you had the proper coverage. What I just read to you is not uncommon. There's an entire plaintiff's bar that focuses on claims against insurance companies, as well as insurance agents and brokers. Without commenting on the law firm itself, a good illustration of this is the website, what I've put on the screen here, covidinsuranceclaim.com. That was provided to me by a Florida defense lawyer we work with. And it just demonstrates that there are plaintiffs' lawyers out there looking to solicit clients to file claims against you. So let's see what we could do to not give plaintiffs' lawyers like this one ammunition against clients and make an E&O claim against you. With this in mind, a good place to start is understanding an agent's legal obligation to a customer, or what is referred in the legal system as duty of care. Your relationship with your customer is no different than any other agency relationship. And under the corresponding standard duty of care, you as an agent need to exercise good faith, carry out instructions with reasonable care, obtain the requested insurance within a reasonable period of time, or inform your customer that you're unable to do so. The courts have described this basic obligation or standard duty of care of an agent to its customer as an order taker and nothing more. While this does not necessarily help our egos when performing services as an insurance broker and insurance professional, it does help in the defense of E&O claims. In fact, many E&O claims are examined by courts simply asking two questions. What insurance did the client ask the agent to get, and did the agent obtain that coverage? Based on my years of experience in representing agents and brokers in litigation, I would also add a third question. Did you as an agent in any way create a greater obligation to your customer to do anything more or get anything else beyond the standard duty of care I mentioned above? Before turning to what situations you may have a heightened or a greater obligation that I touched upon, under the standard duty of care, what this means is that you are not legally required to advise or provide guidance as to the adequacy of coverage or recommend higher limits or different or broader coverages. Rather, the courts in most jurisdictions will look to the customer and say it is the customer's responsibility to advise the type of policy that's being requested, how much coverage is being requested, and can they afford to pay higher premiums for greater or broader coverage. By saying all this, I understand and appreciate that the standard duty of care simply goes against everything you think of when being a strong insurance professional and providing high quality services to your customer. In fact, I'm not in any way suggesting that you don't provide additional services and be an insurance guidance, advice, and recommendations to a customer. What I am doing, however, is cautioning that if you provide services beyond the standard duty of care and obtaining the requested coverage or advising you can't do so within a reasonable period of time, and you provide advice, guidance, or recommendations, you may be held to that higher duty of care. You may be held legally responsible for such advice and or recommendations. I stress the word may, because simply providing advice or recommendations does not in and of itself create this heightened duty. Question becomes, what does? It is a special relationship, which is a term of art in the law, between an agent and a customer that creates this enhanced duty. If you've been involved in an E&O claim or lawsuit, odds are you've heard your attorney use the term special relationship at one point or another. What this means in the end is that absent a special relationship, you are not liable for any advice or guidance you provide to a customer. I've won many cases where, for example, it was alleged that my agent client misrepresented something, whether it be the scope of coverage, how much limits a client may have, or something to that effect. But the court dismissed the case based on the fact there was no legal, in quotes, special relationship. It's therefore important to look at the several ways you as an agent can create a special relationship with your customer. One such way may be marketing material you send out, where you hold yourself out as an expert, or a broker agreement that you may enter into, and the contractual language creates a special relationship. The two I've listed on the screen here are the most common, and the second one in bold in particular is most important today when talking about business interruption COVID-19 related E&O claims. So what's critical to look at is when you've had a long-standing relationship with a customer, you have some type of interaction on the question of coverage, in this case maybe business interruption coverage, and then you as a broker or agent provide advice, and your customer relies on that advice and your subject matter expertise to his or her detriment. There are a couple of special relationship issues worth pointing out. One is just because you have a large client or a client with many policies, that in and of itself, for example, is not enough to create a special relationship. Also, you may have a long-term client who you know has the ability to pay for more insurance or pay for higher limits. Again, this alone doesn't create a higher duty of care. Even if it's your neighbor, you know they can pay for higher limits or broader coverage. Again, that doesn't create this special relationship. Rather, it is the nature and extent of the consultation that the court will look at. I've spent entire 2-hour seminars talking about duty of care and special relationship. I certainly won't bore you, and that's not my purpose here today. I just wanted to introduce it as a foundation to understand and manage that duty in this COVID-19 world. The Great Recession of 2008, Hurricane Harvey, Hurricane Katrina, Superstorm Sandy, they all taught us that clients, especially in time of a crisis, personal, financial, are simply unrealistic in what they expect of you as their insurance broker. If a customer is not covered under a policy, or if he or she receives less than what they expect to receive as part of a loss or a claim, it will often be viewed as a mistake on your part. Now, not every client is litigious, and therefore it's useful to identify some possible red flags where you could use to identify a problem client. And when I say problem client, meaning one that will turn to the blame game. We have seen from metrics and looking at claims and the type of claimants that exist, the following are signs of such a problem client. A client that failed to disclose prior losses. A client that's always late paying premiums. A client that badmouthed the prior broker. All of these type of scenarios identify signs of someone who is more likely to file an E&O claim. Some of my former law partners represented doctors in med mal cases. They would often tell me that one of the reasons a doctor would be sued, regardless whether a mistake was made, was simply bad or no communication at all. The same holds true for you and your relationship with your client. And it's therefore useful to look at some basic communication standards that you should maintain and try to keep in consideration when dealing with your customers. Obviously, there are many scenarios during which you will communicate with a client. From the time that you're soliciting them, from being a prospect to becoming a customer, to the time of a loss. Regardless of the subject matter, there are certain management tools to keep in mind with each communication. You need to make sure your client knows what to expect of you with each service and each transaction you provide. Your client needs to understand what you can and equally, if not more importantly, what you cannot do. A good example is the situation I had last week where a client E&O was non-renewed because they write medical suppliers, and their E&O carrier was concerned that in this COVID-19 world, medical suppliers would be subject to more claims, and in turn, medical suppliers might be more frequently a possible claimant against our agency client in the E&O world. So the E&O incumbent carrier decided to non-renew. We had to go out there and look for a new carrier to place the agency client with. The situation was a little complicated only because last year, it could have been worse by the way, last year we moved the client to a new carrier that was undercutting the market across the board, and we ended up saving the client about $50,000 or $60,000 in E&O premium. Now, the client was paying well below market rates, and I made sure the client understood that this savings was due to a couple factors as to why this particular carrier in question was undercutting the market. So this year, when we went to get new quotes and new premium for their E&O, the client was not shocked when they were looking to pay 2 or 3 times more than they were paying the year before. I made sure that my conversation was documented as well. So having this communication, managing their expectations at the start of last year's policy was crucial in dealing with their renewal, or in this case, their non-renewal this year, and preventing any finger pointing against me or any potential E&O claim. I'll talk more a little later about communications, especially in dealing with COVID-19 related losses, claim prevention. But sometimes it's better to work backwards, looking at the results of your communications, and this way identify the type of claims that could be made against you in this COVID-19 environment. As I mentioned before, the focus so far has been on commercial businesses, property policies, and the availability of business interruption coverage. So again, that will be the focus of my attention here as well. To start with, it's important to understand that the type of COVID-19 related E&O claim that has been made or will be made will likely be the same type and no different than any E&O claims that have been historically made against agents and brokers. The E&O claims may differ in this COVID-19 world in terms of volume. We do expect a higher volume of claims. There may be some greater notoriety surrounding these claims because of the situation we're in. And if a case were ever to go to court, there may be more sympathy resting with an insured who may have been put out of business because of COVID-19 than a particularly other E&O situation. However, the nature of the claims themselves will be similar, and there's no reason to reinvent the risk management wheel. Rather, we simply just need to refocus our attention to minimize the potential impact of these claims. So what am I talking about? It could be alleged that you failed to procure requested coverage, such as business interruption, that you failed to obtained insufficient limits, or you placed a customer with an insolvent or non-admitted insurer, and that's the type or nature of claim that may come down the road if an insurance company is unable to handle all of the business interruption claims and end up becoming insolvent. It may be claimed that you failed to forward a loss notice or failed to timely forward a loss notice or loss information to a carrier. If you issued a certificate of insurance with respect to a property policy, it may be claimed that you did something erroneous with respect to that certificate, failed to put business interruption and coverage on there when it did exist, or vice versa. There may be gaps in coverage if you purchased or procured a commercial property policy with multiple locations, and instead of putting a blanket business interruption limit on, you had limits for particular locations, and therefore there might be gaps in coverage or insufficient limits created at one location as opposed to another. And as I mentioned before, if you do give advice, guidance, or recommendations as to the policy or coverage thereunder, there may be allegations that you failed to explain, failed to advise, or you misrepresent the scope of coverage. So those are the legal theories or nature of claims that could be the basis of a COVID-19 related E&O claim against you. As a practical matter, what's the client going to complain about? I thought I had business interruption coverage. My agent told me or led me to believe I had business interruption coverage. I did not know I could purchase business interruption coverage. Or my agent told me how much business interruption coverage I needed, and in fact I needed more, and they failed to tell me the right amount to purchase. I did not know I needed higher business interruption limits. I did not know my business interruption coverage excluded specific things from coverage like a virus or pandemic. My agent told me not to submit a claim because my policy did not cover my losses. My agency told me not to submit a claim because the government and the courts were going to get me the coverage. My agent told me that he or she would fight for me. They'd be my advocate. They'd negotiate with the insurance company after my claim was denied, and they failed to do so. So those are the kinds of things that your client may be alleging against you as a practical matter. My wife was born in Hungary, raised in Sicily, so you can imagine she's pretty straightforward and blunt. She told me that the only man she would leave me for is a fairly famous chef, celebrity chef Thomas Keller. He owns many famous restaurants in the world, French Laundry and the like. He makes killer buttermilk fried chicken at a restaurant called Ad Hoc in Yountville, California. And one of the reasons I was on the elliptical this morning. But to add salt to my wound, I read this article written by Thomas Keller a couple weeks back now, posted on NBC News Online about the lack of business interruption coverage being provided to his and other restaurants. In fact, when I get to it a little later about litigation, he actually combined with other restaurants and commenced a lawsuit for coverage against several insurance companies. But I did find the opinion piece that he wrote online compelling, And if I didn't work for and represent insurance companies for so many years, I think it would be very persuasive. And I do think that it's important to read what he said to understand the landscape that we're operating under. So some of the things that he said: we bought business interruption insurance to protect our employees in restaurants. The insurance companies are relying on policy language to exclude coverage that's not in the policy and simply not true. The insurers have $822 billion in claim reserves, our money, and should be covering us, especially when we need it most, and not try to run away from their obligations. In this current pandemic environment, this type of language is going to have a strong impact on public opinion and politicians alike, not to mention the plaintiff's attorneys who are going to be screaming from the proverbial mountaintops the same things I've just read to you before. So I'd be a little remiss if I didn't briefly touch upon what the crux of the business interruption issues that are in dispute right now. Okay, I'm not a first-party property expert, but as most of you probably know, in most property policies that provide business interruption coverage, actual physical damage to tangible property is needed to trigger coverage. The most common examples being physical damage from natural forces such as fire, wind, lightning, and that. Contagious disease passed from one person to a person is not physical damage. And about 15, 20 years ago, after SARS virus in 2003, starting in or about 2005 or so, insurers started to add viral, bacterial, and even some pandemic exclusions to business interruption coverage. The insurers in response are mostly arguing that there's no tangible property damage caused by COVID-19, where if there is excluded. And I'll get into a little more depth of some of the arguments that are being made on both sides. But there was a lawsuit filed against a London syndicate, Primetime Sports versus DTW 1991, and I thought that DTW 1991's motion to dismiss that they filed with the court presented a pretty good summary of some of the arguments that are being used by the insurance industry, and a couple of unique, creative, but I think powerful defenses to business interruption claims. So in that case, the syndicate argued that the property has not been rendered uninhabitable by the virus. And so it could conduct carry-out business-like restaurants, for example, and that was Primetime Sports. They were saying that they were a restaurant, they could do carry-out business, and therefore they're not uninhabitable. And that other facilities that have confirmed presence of coronavirus, such as hospitals, medical clinics, nursing homes, they've all remained open, and employees continue to work. And the quote I thought was equally persuasive was, "The virus requires that appropriate precautions be taken, but it does not cause direct physical damage to the property itself, and it does not destroy the property's physical utility as a structure or render it uninhabitable." Again, the case I'm talking about, in case you want to look it up, it's called Primetime Sports versus DTW 1991. Before I move forward, I mentioned before there are other types of insurance policies that are being impacted by COVID-19, both directly and indirectly. For example, on the claim side, we handle long-term nursing care facility programs, and we're seeing claims by employees and residents claiming a failure to provide a safe place to work or live. We equally see claims by family members for emotional distress, for not being able to see or visit loved ones, especially those that subsequently pass away. On the production side, we write broker, dealer, and financial institution business, and we're seeing thus far a significant increase in market fluctuation claims due to the ebb and flow of the stock market over the last month or two or more. We do expect to see bad investment type claims also down the road in this segment of business as well. Back to business interruption coverage. This issue undoubtedly be decided differently depending on the jurisdiction you're in, at least until the issue is addressed by the states or the Congress and legislation. And I'll go through a couple of cases here. In Gregory Packaging versus Travelers, for example, and these are some cases that, just looking back, may be useful to analyze how the courts may look at COVID-19. So in Gregory Packaging versus Travelers, a New Jersey court found an ammonia leak that shut down a manufacturing plant. was physical loss or damage because it rendered the business uninhabitable or otherwise unfit for the business intended use. So while they found business interruption here, it's useful to again point out with that DTW case I mentioned a moment ago, most businesses are shut down, but they're not uninhabitable and they are fit for the business intended use. So there's on the other side of the equation, in a case called Source Food Technology versus USF&G, a company sought business interruption coverage after the USDA prohibited the importation of beef products from Canada. Cows had tested positive for mad cow disease. And that federal court, which was the 8th Circuit, the federal court found that there was no coverage for business interruption because the beef product that was embargoed was not contaminated or damaged in any way. Another way to look at the business interruption losses that are out there is that they must be supported by actual losses. So the case I have on the screen here, Dictiomatic versus USF&G. An insured filed a claim for business interruption coverage following a major hurricane. The office building where at least space was damaged and they couldn't get access for several weeks. The court in that case found there was no coverage under the policy because the insured suffered income losses throughout its entire period of operation immediately prior to the hurricane, and there was no proof that the insured could have achieved profitability during the period of business interruption or immediately thereafter. So I bring that up because even if there is business interruption claim, doesn't necessarily mean that automatically leads to claims being paid. Business interruption claims, any financial loss claims can be complex. And it's similar to proving lost profit damages in a commercial case. Causation and losses must be well documented and mitigation efforts need to be made where possible. So I had a case many, many years ago involving a Chicago hotel, and I'm dating myself now because there were yellow pages, and the Chicago hotel was omitted for a particular year from the yellow pages under the hotels. And the Chicago hotel was then claiming they lost all this business because they weren't in the yellow pages for the year in question. Well, we had a jury trial, and in fact, the jury came back and found that my client was liable for failing to list the hotel in the yellow pages. However, the trial court also found that their damages were zero. And the reason that was for the years leading up to the omission, the Chicago hotel was hemorrhaging money, was losing money, and they couldn't really say that there was a causal connection between the omission and any future potential profits down the road. It could be bad weather in Chicago, strikes, things of that nature could also impact profitability. So again, it's difficult, it's complicated, so even if there is business interruption, it's not necessarily a slam dunk. Another avenue besides tangible property that's being explored for COVID-19 coverage is that a commercial property policy may also cover losses sustained when a civil authority order requires a business to shut down because of physical loss of damage to a neighboring property. So this is another argument that's being made out there. And a couple of key issues which I'll touch upon with some case law as well is that there must be a causal connection between the government order and that physical damage. So you've heard me use the term order a couple of times. It's got to be a government order. So what about those states out there, South Dakota, for example, where there is no order, or maybe there isn't South Dakota, but Alabama, Tennessee, where there is no government order for shelter at home or to shut down businesses? That would appear to render the civil authority coverage not applicable. So I would keep that in mind, that it does require a government order. I would also point out that this coverage typically has time limitation issues with most of the civil authority coverage, usually coverage for 14, 30, or 60 days or something for that effect. So the arguments for coverage under the civil authority coverage is that COVID-19 should be covered as a source of loss because the virus created physical damage to the property is located within the boundaries of a civil authority shutdown, and that there's an ongoing dangerous physical condition during the civil authority shutdown that has resulted in business interruption losses. On the other side of the equation, the arguments against coverage is that COVID-19 doesn't constitute physical damage because it could be removed and it does not permanently alter a property. It is also argued that social distancing is the reason for the civil authority orders, and social distancing is not covered. It's also argued that the shutdowns were to avoid potential future physical damage, which would not be covered, rather than damage to the property itself. So there's a case out there, United Airlines versus the insurance company of Pennsylvania, and after the 9/11 terrorist attacks on the Pentagon, the civil authority ordered Reagan National to be shut down. So United Airlines sought civil authority coverage for economic losses relating to the closure of Reagan National. The court in that case, it was the Second Circuit federal court, held that United Airlines was not entitled to civil authority coverage because the airport was shut down before the attack on the Pentagon, and it was not a direct result of damage to any adjacent property, which was required by the policy. The evidence showed in that case that the shutdown was based on the fear of future attacks. In contrast, in a case called Sloan versus Phoenix of Hartford Insurance Company, the court did interpret civil authority provision to apply, not requiring physical damage or property to trigger coverage. So that case involved movie theaters and owners and operators sought business interruption coverage following a curfew ordered by a Michigan governor in response to widespread riots. This was the early 70s. The court held that there was civil authority provision coverage to comply with the governor's order. So these are, again, some of the issues that are out there. I want to give you a little case law and some of the flavor and feel for what's coming up and how it may impact on COVID-19 related claims. So if you read industry publications almost every day, you'll read something new about a lawsuit being brought against insurance companies for business interruption coverage. I bring this up because E&O suits against agent brokers have historically either been tied to or followed these type of coverage claims against carriers, because in the event the courts decide there's no coverage, the plaintiff's lawyers will want to make those claims against the agent and broker. So in these lawsuits, one of the primary arguments advanced to support the claim for coverage is that COVID-19 attaches to business property services, and that constitutes tangible property damage to invoke the business interruption provisions of the policy. Like the case I mentioned before, and I always twitch when I say the name Thomas Keller, but like the Thomas Keller restaurant lawsuit, the one I have on the screen here, El Novella Restaurant, is an industry-based class action lawsuit brought a few weeks ago in the Southern District of Florida. And this one, like other lawsuits, are class actions. They're industry-driven. And this one, it's being alleged, another common argument, in addition to the attaching to business personal property services that I mentioned before, namely that the existing industry-wide business interruption exclusions are illusory, namely that standard policies need to and do not specifically exclude, quote unquote, a viral pandemic. Rather, they may exclude a virus, may exclude a pandemic, but they don't define what that is, and they certainly don't exclude specifically a viral pandemic. Now, insurance companies are going to respond, and I mentioned just before how the syndicate in DTW 1991 responded, but they're going to respond that insurance policies are like any other contract. You can't go outside the scope of the policy to find for coverage. They're going to also argue that policyholders had the opportunity but chose not to buy business interruption coverage, had the opportunity but chose not to buy higher business interruption limits, or in certain situations will argue that they had the opportunity but did not provide, or excuse me, did not purchase business interruption coverage without any exclusionary language. And it's with this second argument that there could be claims against the agents and brokers by customers because one of your clients may now claim is, hey, I didn't know I could buy business interruption coverage. I didn't know I needed higher limits, and I certainly didn't know I could buy it without any exclusionary language for virus and pandemic. The courts are not the only place business interruption coverage issues are being raised. More than a dozen state legislatures have proposed bills that force in some fashion insurance company to pay any and all business interruption claims, regardless of whether the policy provides such coverage. Not all states, but some of them are requiring business interruption to at least be in the policy. And they're also forcing insurance companies to pay whether there is an actual tangible property damage and whether an exclusion may apply. Now, these bills vary from state to state, but they all include that providing retroactive business interruption coverage to the date that the COVID-19 pandemic was declared an emergency or a disaster in each state. Some states like Pennsylvania, Ohio, New York, and Massachusetts, at least in the proposed bills, are limiting the obligation of the carriers to pay to smaller businesses, meaning 100 to 150 employees or less. Now, all of these state bills, in my view at least, face significant constitutional issues and hurdles. Namely, there is case law out there that limits the ability of statutes to sometime impose some kind of retroactive contractual obligation on a party. In this case, it would be on the insurance companies. And I think if any of these state acts are ever passed, first of all, there's going to be much more debate on it, but it's certainly going to lead to some court constitutional challenges if passed. I would also note, Hiscox and Beasley a few weeks ago estimated they're going to pay up to $345 million or so for covered claims. Axis, about $235 million, and I think AIG estimated about $272 million in first quarter COVID-19 related losses. These numbers don't even include uncovered claims that a state may require them to pay if any of these bills are passed. So as you could expect, the insurance company and the companies and their lobby are pushing back fairly strongly, saying that if they're retroactively obligated to provide this coverage, they're going to go insolvent. So with all the plaintiff and insurance company lobbying going on, we may in the end see a 9/11 type insurance set up, something like a Terrorism Risk Insurance Act or TRIA or something to that effect. Before I do turn to federal legislative activity, the states are also dealing with other insurance business lines as well, besides just business interruption coverage. So I mentioned nursing homes a little earlier. So there are COVID-19 related nursing home claims out there, and the industry has pushed for states to issue bills, namely the nursing home and hospital industry, for immunity arising out of COVID-19. So 6 states or so have done so, and at least 6 more are looking at granting some form of immunity to healthcare providers, which may be interpreted to apply to nursing homes as well. Now, with this immunity, I raised some questions. What does it mean? Does it mean absolute liability for anything having to do with COVID-19, or does it just mean negligent claims? The reason I bring this up is because the families and the plaintiffs' bars, you can imagine, are pushing back. And they're saying if you give such immunity, that's going to lead to further neglect and abuse. Just like we saw 17 bodies found in that makeshift morgue in New Jersey last month, and the U-Haul truck with 17 or so bodies in Brooklyn a few weeks ago. On a federal level, Republican Mike Thompson of California introduced what's called the Business Interruption Coverage Act of 2020, House Resolution 6494. That bill by their sponsors was described as one to ensure businesses who purchase business interruption insurance will not get their claims denied because of major events, such as coronavirus pandemic. And it was designed as a, quote, solution to help small businesses and owners and their employees, those that power our economy. Now, the bill itself is not limited to small businesses, but as we've seen in the past, things get negotiated between Congress. We'll see how this all shakes out. There is some provision in a lot of that statute which allows the federal government to reimburse the insurers for the cost of paying COVID-19 related claims. There's also an ambiguous provision in this bill that gives the insurance companies right to reinstate BI exclusions, something to that effect. But as I mentioned before, this just came out a couple of weeks ago. The House of Representatives, not even in Washington, so it's kind of stood out there a little bit. But there is a TRIA-like statute being discussed as well, and this is one I think that may have some teeth ultimately. It's called the Pandemic Risk Reinsurance Program. And this is a proposal to create what would be known as, again, the Pandemic Risk Reinsurance Program that, if passed, would offer insurers an opportunity to share a portion of covered business interruption losses with the federal government. And I put share in quotes and I put covered in quotes. So it's designed to get money to businesses. It's designed to prevent the withdrawal of insurance companies from the marketplace as a result of COVID-19 and similar future circumstances. It's voluntary. So participating insurers would have to agree to enter into the program, and they would agree to extend business interruption coverage in their policies to cover losses resulting from a covered public health emergency. And I use that term because it's pretty broad to be designed not only for COVID-19, but similar future circumstances as well. The bill would invalidate any exclusion in the contract for those insurers that participate. And if they have an exclusion that excludes losses for a pandemic or environment, that would invalidate that exclusion with respect to business interruption losses. Now, the insurers could seek to introduce that exclusion or even a different version of the exclusion if the insured company agrees in writing to the placement of such exclusion back into the policy. The insurance company could raise rates to accommodate the expanded coverage that they're providing. If a business chooses not to pay the increased premium, however, the insurance company has a right to treat any loss that's reported as if the exclusion had not been removed. Now, this bill would not invalidate all exclusions. It only applies to those participating insurers in the program, and in exchange for that, they agree to provide this coverage to damaged businesses for business interruption. Lastly, I would note that the program is proposed to be handled through the Department of the Treasury, and right now it has an annual cap currently proposed at $500 billion. And I do think that ultimately, if the insurance industry lobbyists, if the plaintiffs' bar and Congress get together, this might in the end be something that we see happen, some form of this pandemic risk reinsurance program. So with all of this judicial governmental landscape, I'll turn back to how we started the day. For you as an insurance agent or broker and your day-to-day issues that you face dealing with your customers, and start to think about these COVID-19 related questions. Does your customer's commercial property policy contain business interruption coverage? Does your customer's business interruption coverage have sufficient limits to cover a loss? Should your customer gather information and complete loss forms to submit to a business, submit a business interruption claim to a carrier? Should you submit a claim to an insurer for your client if that client's policy does not provide business interruption coverage or may have an applicable exclusion? Should you, and if you should, how should you help a customer whose business interruption claim is denied? Should you tell your client to wait and see what happens with Congress, the courts, state legislatures, things of that nature? As to that last point, one thing to keep in mind with all this claim reporting discussions, commercial property policies do have time limit and notice provisions, and you certainly don't want to create another reason or two for an insurance company to deny coverage with an untimely or incomplete submission of a business interruption claim or loss. So what are you supposed to do? What should an agent do to assist the customer while at the same time employing risk management strategies to prevent or minimize an E&O claim? First of all, respond timely to all client inquiries. Don't be defensive to questions like, do I have coverage? Why don't I have coverage? Do I have enough coverage? Never admit fault or that you did anything wrong. With respect to that last point, most of your E&O policies likely have an admission of liability condition, and if you admit fault or liability, you could theoretically jeopardize your E&O coverage. You certainly don't want to do that. I mentioned timely responding to inquiries, and I'll get to that a little later. but you want to make sure that you don't put your head in the sand, that you respond quickly. Clients want to know what's going on, and they really want to know yesterday in today's world of internet and email. They don't want to know days or weeks from now. Secondly, with respect to coverage questions, do not provide an opinion as to whether one particular customer's claim will or will not be covered. Don't provide whether there's specific coverage under a specific policy or situation. I think it's okay to provide the 10,000-foot view of things, as I mentioned before, that tangible property damage is typically required with business interruption. Many policies have exclusions for viruses and the like, and in fact, if your customer's policy does, point it out. But you do want to point out the issues are very fluid right now, since many policies do not provide this type of coverage. In fact, many insurance regulators have come out and said they don't think there's coverage for business interruption for COVID-19, but that the courts and the legislatures are looking at it. So what should an agency do on an agency level? If anyone at your agency has done any of the things I caution that you should try to avoid, things of that nature. And I do think one motto should be there for all of your agents and all of the people in your agency, namely to stay out of the way of the claim submission and decision process. That being said, don't bury your head in the sand if you have gotten involved in it to some degree. It's not too late to cure what could become an E&O problem down the road. Don't be afraid to reach back out to clients. For example, if a client contacted your agency and inquired about filing a claim, but you may have in any way discouraged a claim or not timely provided loss forms and the like, it should be not too late to do so now, and you certainly want to stay on top of it. But with respect to these communications with your clients and your customers, as I've talked about already, it needs to be consistent with whatever agency-wide service standards that you've established. So you're being consistent with timeliness and documentation as you would pre-COVID-19. I've asked with other presentations to provide, if I have, some service standard slides and the like. If that's something you're interested in, again, my email address is going to be at the end of the presentation. Certainly feel free to email me if you'd like to have some slides I've given in other presentations with these service standards that can range from anything from coverage to how to deal with emails in an agency, texting, things of that. So certainly feel free to reach out to me to get copies of that. Back to communication for a second, kind of where I started the discussion earlier. It may seem like a couple hours ago, but hopefully not. I talked about managing expectations, letting a client know what to expect, what you can, especially what you cannot do. Client education is an ongoing process. It happens from the first time you meet a client, but the same holds true for the first time you're contacted about a business interruption claim in this COVID-19 environment. This too should be looked at as a new and critical opportunity to educate your customer and manage expectations. Again, let the client know what you will be doing and what you won't be doing. Don't assume that a client knows about the claim and submission of a loss, even if you've handled claims before. Provide a reasonable timeline providing these services, pointing out that people being sheltered at home may impact this timeline a little bit. You certainly could share, and we've all probably experienced getting on the phone with vendors where we used to be maybe 2 or 3 or 4 people ahead of us. We're now 600 people in the queue, and it may take hours to get through to people. So it may impact people responding to losses. So provide this timeline reasonably to your client. And maintain a realistic diary to keep up with your clients. So you make sure that you touch with them on a weekly, every 2 weeks or monthly basis. Keep them apprised of what's going on with all claim developments. It's good to keep in touch even if nothing is happening at the moment. I think that's a critical risk management tool. And I can't emphasize enough. The more your customer knows about the process and what to expect, the less likely they are to file an E&O claim against you when a problem arises. With these clients' best practices in mind, they do apply to each and every transaction you have with a client. they become even more critical when dealing with a catastrophic situation. As you see from my earlier slides and discussion, the plaintiff's bar is just starting class actions against insurers, and claims and lawsuits against agents and brokers are undoubtedly to follow. If it's possible to be even more diligent than you were before, please do so with respect to COVID-19 issues, business interruption, and the like, and I emphasize just the following. If you're asked a coverage question on a subject that you're not an expert in or do not know the answer to, don't be afraid to say so and seek and get the answer from someone who does, and give a qualified response to your client. Practice policy coverage within your area of subject matter expertise. When I used to prepare clients for a deposition, I would always tell them, don't be afraid to say, I don't know. People are always afraid to say that. I think they'll come across as stupid or not being responsive to the question. You might be hesitant to say, I don't know to a client. I certainly understand and appreciate that. But you want to make sure you're practicing your area of subject matter expertise and you know what you're talking about. When I was managing my law firm, I used to use the phrase something to the effect, I only appear as tall because of shoulders that I stand on. And what I mean by that is you will be a stronger insurance professional. You'll minimize or prevent E&O claims if you rely on the strengths of others at your agency to answer questions of your clients. And I kind of talked about this before, but as in real estate, when you have location, 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 to prevent E&O claims, it's document, 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 and timeliness, timeliness, timeliness. Documentation cannot be stressed enough. It's the key to any E&O defense. If you can't rebut in writing what a client is claiming, a case becomes a gray area. You want to take that he said, she said, likability, questions of credibility out of the equation. Anything not in writing is subject to dispute. And the same holds true for timeliness. I use a phrase, a client who is unaware of what is going on is the tip of a match waiting to be lit. This is kind of brings us to the end and nature and scope of communications with a client. And I just want to talk about, when you talk about these last things, when it comes to particular claims and coverage communications with your client, you need to make sure of the following. Whatever critical representations you make, whenever you talk, don't overstate. Stay within the confines of what you're talking about, the policy language and the like. People tend to overstate and want to say what their customer wants to hear. That's not going to work. Doesn't lend itself well, and it comes out to haunt you if there's an E&O claim. Submit all claims to an insurer immediately. Don't make coverage determinations on insurance companies' behalf. Don't make predictions as to whether a loss will or not be covered. And don't negotiate with the insurer after one of your customers' claims may be denied. If you think that the insurance company missed it, language in the policy, it's okay to point that out, but don't get involved in negotiations between a client and a customer. That's not something for you to do. If you do get involved, you want to document that you're acting with authority and instructions of your client, and document every decision that the customer makes in writing, as well as maintaining all written documentation of all your actions in responding to the situation. And I ask that you do so contemporaneously. If you try and recreate conversations or events that took place days or weeks later, memories fade. I have 4 kids, can't remember their names, and my kids remind me that all the time. I use that to maybe as a little bit of an exaggeration, but not too much, but memories do fade. Lots of things are running around out there, especially in this time, when times of stress. You want to make sure that you put it down contemporaneously. And any agreement that you have with a client or a customer, put that in writing, even if it means that you assert and you affirmatively send out an email confirming a conversation, request for an action, or to follow up. So I want to thank you for your time. As I mentioned before, I've been asked in other situations to provide both service standard material. I've also been asked to provide some reference material. And over the last couple of weeks, I have collected some items, mostly posted on other law firm websites, like a COVID-19 first-party insurance frequently answered questions, a 50-state tracker of legislation, litigation, and other activity. So if that's the kind of thing that you're interested in and you'd like to get copies of that, certainly feel free to email me. call me on my cell phone below, leave a message, I'll certainly get back to you. Or if you have any questions on some of the items that I touched upon today, I certainly do appreciate your time and listening to this presentation. I wish everybody continued good health, safety, and success. Thank you again. Take care. Bye-bye.